I'd like to begin by acknowledging the traditional owners of this country. I'd like to welcome you all to a momentous occasion for the College of Arts and Social Sciences and the Research School of the Humanities and the Arts. It's so pleasing to see so many representatives of government and community organisations. The Freilich Foundation has been integral to the development of the Research School of Humanities and the Arts. It's endowed by Dr. Herbert Freilich and Valmay Freilich to research into the causes, the histories, and the effects of ethnic, cultural, religious, and sexual bigotry and animosity, and the exploration of how such intolerance can be combated and coexistence promoted by educational and social programs. And we know from the recent British election how controversial the topic of bigotry can be, and how brave and necessary it is to combat bigotry by enabling people to recognise its presence, both to recognise it in others but also to recognise it in themselves. The Freilich Foundation, through its support of distinguished lectures, conference programmes, publications and research, has been part of the profile of the RSHA from the very beginning. Until now, the Foundation has supported an academic staff member to support, manage and develop the programmes. We've been incredibly lucky in the two people who have occupied that position, Benjamin Penny in the past and now Renata Grossi. They worked with the Freilichs to set it on firm foundations. But I'd also like to acknowledge the great support given to us by Joan Ure, who's the Director of Endowments at the ANU, Debjani Ganguly, who's the Chair of the Foundation, and Mandy Thomas, the PVC for Research. Now, the aim has always been to create a professorial position to enable the Foundation to take an increasing leadership role in these areas and to be very much part of global discourse on bigotry and intolerance. And thanks to Herbert and Valmay's generosity, we were able to advertise a chair last year. And as a result of that, we're fortunate position to welcome Penny Matthews to the Foundation Freilich Chair. And one only has to read her CV, which one will do on the website of the Freilich Foundation, but also from the number of people here, her CV in as many people's minds. She's the ideal person for this particular position. Her career has been devoted to human rights and particularly to the rights of refugees. I can only summarise a very few aspects of her career. She's a non-judicial member of the International Association of Refugee Law Judges and a member of its Human Rights Working Group. Her evidence to the Australian Senate's Legal and Constitutional Committee concerning the Migration Amendment, designated Unauthorised Arrivals Bill 2006, a bill which sought to extend aspects of the Pacific Solution, was cited extensively by the committee when it recommended that the bill should not become law. From 2006 to 2008, she was a legal advisor to the ACT Human Rights Commission, where she conducted the human rights audit of the ACT correctional facilities. Before returning to the ANU, Professor Matthews was the interim director of the program in Refugee and Asylum Law at the University of Michigan Law School, where she convened the 5th Michigan Colloquium on Challenges in International Refugee Law. We're delighted that Valmay Freilich is present to hear this lecture. Sadly, Herbert Freilich died last year, but had been told of Penny Matthews' appointment to the chair. I have a lateral question that I often ask at interviews for professorial appointments. What topic would you choose if you gave an inaugural address? A very good question. Unfortunately, it won't come as a surprise anymore to anybody who's coming to be interviewed by me. And I'm not sure I asked Penny that question, but we're all here to hear her answer. And the topic is, where to from here? Australia's role in refugee protection. Penny.
Thank you very much for those very kind words, Howard. I feel very humbled to be here. Thank you all my friends for coming to hear me speak, and thank you especially to Valme for being here. It's wonderful to see you all. Well, on 9 April this year, the Rudd government announced a freeze on applications for asylum from Afghans and Sri Lankans. From that date, no new applications by Sri Lankans would be heard for 3 months, and no new applications by Afghans would be heard for 6 months. The freeze met with criticism from many human rights activists, as well as the President of the Australian Human Rights Commission, Justice Cathy Branson. And that's rather a contrast to the very warm reception for many other measures taken by the current Labor government. They include the abolition of temporary protection visas, the abolition of immigration detention debt, reform of the 45-day rule restricting work rights for asylum seekers, and the closure of the offshore detention centres on Nauru and Papua New Guinea. The aim of the freeze is people smugglers and those who use them. It's envisaged that when decision-making resumes, some of the asylum seekers will be sent home. Now, the reason for repatriation would not hinge on people smuggling. If we look at the definition of a refugee contained in the 1951 Convention relating to the status of refugees, we see it's a person who has a well-founded fear of being persecuted for one of 5 grounds and is outside their country of nationality and unable to return or to avail themselves of the protection of that country. You are not disqualified if you use a people smuggler to get somewhere. Indeed, the way that a refugee comes to be in another country is generally irrelevant under the Refugee Convention. There is a provision that deliberately exempts people who enter irregularly from being penalised in recognition of the practical barriers that refugees face. So although the freeze is directed against the use of people smugglers, the reason the government anticipates some repatriations is the apparent imminent change in circumstances in Sri Lanka and Afghanistan. Well, this begs the question, why not allow refugee status determination to take its course? If people are not refugees because circumstances have changed, they will be sent home. It's questionable whether an election or two and the end of a bitter civil war and a period between 3 and 6 months is sufficient to effect the sort of change required to bring a person's fear below the level of well-founded. An asylum seeker has to show that there is a real chance of persecution, which could be less than a 10% chance. In cases where a refugee cannot back up their claims but they appear credible, they're to be given the benefit of the doubt. And although someone recognised as a refugee may cease to be a refugee, for that to occur there must generally be a fundamental, durable and stable change in circumstances, or the person voluntarily goes home, for example. In other words, if we are serious about refugee protection, it's better to err on the side of the asylum seeker than to risk sending someone back to a place of persecution. So it's not surprising then that many have speculated that the freeze is in fact a political decision designed to tide the government over the election period. It's very tempting to conclude that the government is worried by opinion polls. After all, on April the 20th, a poll came out showing the opposition had taken a lead of 18 points on the question of who was better able to deal with asylum seekers. But the assertions by the opposition that they will turn around the boats, that we need to return to the policies of the past, and that these policies were successful, require very close scrutiny. While asylum seekers anxiously wait in detention for decision-making to resume, we Australians have the luxury of taking reasoned decisions about how we receive asylum seekers. So let's look at the policies of past and present governments against the backdrop of the problem with which they're designed to engage and the key legal instrument designed to respond to the problem. We'll begin with a look at the 1951 Convention, examining some key provisions and some legal questions surrounding the freeze. So after World War II, member states of the United Nations negotiated a new treaty to deal with the remaining refugees displaced by World War II and its aftermath, people fleeing communist countries. This treaty, the Refugee Convention, looked back at the existing caseload of refugees displaced by these events. It was as much a recognition of the reality of forced migration as it was a humanitarian exercise. There was no denying that refugees were here. All that remained to do was come up with a humanitarian resolution of their circumstances. The backward-looking nature of the convention explains its rather restrictive definition. That's actually a very tight definition. And originally it was even tighter. It was limited to people who fled events that occurred before 1951, and parties to the convention had the option of limiting their obligations to people fleeing events in Europe. It was only in 1967 that the international community recognised that refugees are an ongoing issue, and they lifted the temporal and geographic restrictions on the definition. Today there are around 16 million refugees and many more who are internally displaced. And this definition misses out a lot of people who require protection. There are, for example, about 26 million people who are internally displaced, cannot cross an international border. They also require protection. And in many countries, and Australia's not yet one of them, there are systems of complementary protection for people who do not meet this definition, but for example, who have a fear of torture in their country of origin or who are going to be subjected to the death penalty. And in some regions, such as Africa, the definition of a refugee has actually been expanded. The Refugee Convention provides a number of rights to refugees. Most importantly, it contains this obligation, non-refoulement, we use the French term. So no state shall return or refoule a person to a place of persecution. The Convention then envisages a gradual realisation of more rights as the connection between the refugee and the country of asylum increases. So, for example, a refugee who is lawfully staying in a country, and of course there's some debate about what that term means, is entitled to the right to work. So there's a gradual increase as your connection with the country of asylum deepens. Refugee status in the Convention is conceived of as fundamentally a temporary status, and it can cease if conditions in the country of origin improve. There are three commonly talked about durable solutions for refugees, so long-term solutions, and they are to integrate into the country of first asylum, so the first place that they fled to, or to resettle permanently in a third country, or there is the option of voluntary repatriation, which of course is generally only going to happen when circumstances have improved and the person is safe again. These durable solutions are reflected in the Convention but not specifically mentioned as such. So if we think about local integration, to fully integrate you would acquire the rights of citizenship, but that's not actually required under the Refugee Convention. Article 34 refers to facilitation of naturalisation, but it doesn't require states to grant their citizenship to refugees. And resettlement isn't really mentioned in the Convention at all. Obviously, if you are resettled, you will be entitled to certain rights like the right to work under the Refugee Convention, but as a concept, it is not mentioned. It's only mentioned really in the preamble and the recommendations of the conference that were adopted at the time of the drafting of the Convention. So it's really seen as a non-binding obligation. So in theory, immigration control remains in the hands of the member states, and the Refugee Convention doesn't actually grant a right of entry to any state. And it's that gap upon which the Howard government relied when it erected the Pacific Solution. It was claimed that so long as we didn't return people to a place of persecution, we didn't actually have to allow them to enter into Australia. Obviously, however, if the treaty's rights are going to be meaningful, states can't leave people in limbo by refusing to determine their status or by denying that they're lawfully present and entitled to the rights that attach to lawful status. That would not be a good faith interpretation or application of the treaty. After all, the Refugee Convention makes almost no reference to the process of determining refugee status either. as a matter of international law, a person's status as a refugee is a matter of fact, and it's simply confirmed by national procedures determining refugee status. So asylum seekers, people who haven't had their status determined, are presumed to be refugees until they're unable to prove their claims, and a few key obligations apply to them automatically. In particular, the obligation of non-refoulement applies automatically to asylum seekers. So if we pose the old philosophical chestnut, if a tree falls in the forest and no one is around to hear it, does it make a sound? The answer that a refugee lawyer would give is yes. The claims of Sri Lankans and Afghans still sound in international law, even if Australian authorities are currently refusing to hear them. So what might be wrong with the freeze? Well, one provision that the freeze might impinge on is an obligation of non-discrimination in Article 3 of the Refugee Convention. Fairly limited obligation, non-discrimination on the basis of race, religion or country of origin. Lots of grounds of discrimination left out there. But nevertheless, the freeze seems to discriminate on the basis of the country of origin. Now, given that the provision applies, or Article 3 applies to the provisions of this convention, we might say, well, refugee status determination isn't mentioned, so this obligation doesn't come into play yet. However, obviously, lots of other rights in the convention depend on the availability and quality of refugee status determination. And one key provision would be a provision in Article 31 that talks essentially about refugees and asylum seekers' rights to liberty. So states are not supposed to impose restrictions on movements of refugees who've entered unlawfully, other than those which are necessary. Query whether a general freeze on determining claims while we make a general assessment of country conditions can be seen as necessary, given that it would be perfectly possible for the Australian government to continue with refugee status determination as usual. So I think it is arguable that this provision, in combination with Article 3, the provision on non-discrimination, are violated by the freeze. And for similar reasons, Australia may well be in violation of Article 9 of the International Covenant on Civil and Political Rights, a general human rights treaty which of course applies to refugees because they are human beings as well. Okay, so having taken a Cook's tour of the Refugee Convention and outlined some concerns about the freeze, let's look at Australia's history with the Convention prior to the freeze and consider the policies of previous governments. Have these policies deterred boat people from arriving, and is deterrence a criterion of successful policy? Now, although Australia had some experience with refugees prior to and during the Second World War, it really begins its engagement with refugees after the Second World War. It resettles 170,000 people from displaced persons camps in Europe. And Australia played a significant role. We were certainly there at the drafting of the Refugee Convention, and we were the 6th country to ratify, to become party to the treaty. And indeed, it was that ratification that brought the treaty into force, making it binding law. However, Australia participated as a country of resettlement, and it wasn't until the 1970s, with the fall of Saigon, that Australia really begins to receive onshore applications for refugee status in any numbers, and we finally introduce a procedure for determining refugee status in the late 70s. This is just taken from a background note from the Parliamentary Library that gives you some of the statistics on boat people. I've had to do the addition in some cases myself, but you can go to the note and check my addition. So let's have a look at the numbers of arrival and the sorts of policies that successive governments have implemented to deal with these numbers. So Australia receives 2,059 people between 1976 and 1981. In 1992, the policy of mandatory detention is introduced by the Hawke government as a response to a challenge to detention by Cambodian asylum seekers. By 1999, it is clear that detention is not stopping the boats from arriving. We had 86 boats with 3,721 people, which exceeds the numbers arriving in between 76 and 81 when we didn't have a policy of mandatory detention and refugees were housed in open reception centres or hostels. So in 1999, people smuggling becomes a concern for government. And at this point, the Howard government introduces temporary protection visas, as well as the first iteration of border control legislation under which the Navy was given new enforcement powers. In particular, the Navy was given the power to chase in hot pursuit so-called motherships, which sit out outside Australian waters and launch smaller vessels into those waters so that the mothership can escape quickly. I hear people giggling about the language. It comes from the UN Convention on the Law of the Sea, but you should see the second reading speech. It does sound something like science fiction, with the mothership launching the aliens into Australia. Now, it's apparent from the figures concerning boat arrivals and the subsequent adoption of the Pacific Solution that the temporary protection visas and the new enforcement powers weren't stopping boat arrivals either, a point that the current Minister for Immigration made recently in a speech to the Sydney Institute. In 2000, we see that there are 2,939 boat people. 2001, we're up to 5,516 boat people. So those measures are not working, and at this point the Tampa arrives in 2001, and as we all know, Prime Minister Howard refused to let any people on board the Tampa disembark in Australia. Now, if we look at the boat arrivals after the interception of the Tampa and the sending of those people onto Nauru or Papua New Guinea for processing, we certainly do see a drop in boat arrivals. Apparently there was one at the end of 2002, and then for the next few years there are a whole 17 boats. So certainly there are fewer numbers arriving. And the lesson that the opposition takes from this is that interception works, and we should begin to turn the boats around again. Now, this ignores other variables that help to explain the figures. So is it deterrence or is it other things? There was an interception program where some boats were actually turned around and sent back to Indonesia. People weren't just shipped off to Nauru or Papua New Guinea. One boat actually sank in October 2001. Remember, the suspected illegal entry vessel X, with the loss of 353 people, including 146 children. Now, that may well have had an impact on people's willingness to get on a boat. Another factor that might come into play was the fact that Afghanistan was by this stage invaded by the United States, and there was a short-term improvement in security. And also, with the benefit of hindsight, it turns out that 2001 was a peak year for arrival of asylum seekers, peak for a period of a decade, in fact. There were 620,000 asylum claims in the 44 industrialised countries that give figures to the UNHCR. So there are, in fact, a number of other factors that might explain some of the drop in numbers. By contrast, the number of claims in the asylum claims in the industrialised world for 2008 and 2009 are about half the levels of claims in 2001. As far as Australia is concerned, in the last couple of years, there has been an increase in asylum claims that has to be acknowledged. UNHCR reports at about a 29% increase. But UNHCR also says this remains not only below those observed in 2000 and 2001, but also far below those recorded by many industrialised countries. So what we might draw from that is, in fact, that we're just back to situation normal, really, in terms of number of asylum claims. And indeed, the Minister for Home Affairs, Brendan O'Connor, pointed out that we're not the only country that's had an increase in asylum claims recently. Countries like Denmark, Hungary, Finland, Poland, Belgium, New Zealand have also had increases in asylum claims as well. In any event, just looking at numbers of boats and drawing conclusions is a little banal. There are some other important figures behind the numbers of boats and the numbers of people that they carry. In particular, there are the financial costs. Now, it's actually very hard to get a grasp on what have the financial costs of the Pacific solution been like and what is the cost of the interception program. The figures were first investigated during the Senate Legal and Constitutional Committee's inquiry into the Migration Amendment designated unauthorised arrivals bill that Howard mentioned in his introduction. We might just call this Pacific Solution Round 2, in which the government tried to extend the Pacific solution to the whole of the mainland, not by excising the mainland like Christmas Island, but by inventing a fiction about the people. That's why they're designated unauthorised arrivals. The explanatory memorandum to the bill claimed that there were no direct financial implications from the bill. It simply provides the flexibility to the government to move a wider group of people to offshore processing. Advocates immediately seized on this. This couldn't possibly be true, that it wasn't going to be more expensive to process people on Nauru and Papua New Guinea and to have the Navy out intercepting boats. So, for example, the non-government organisation Adjust Australia looked at federal government estimates and said, well, we think it's going to be $195,000 per person on Nauru versus about $38,000 per person at Baxter Detention Centre on the mainland. In part, perhaps because it's so difficult to do a budgetary breakdown, the department's final formal response to the committee was simply there is no budgetary breakdown of the costs per offshore processing centre resident. So, very difficult to work out what the actual costs are. There are some independent sources, estimates of costs. So, for example, Professor Jim Jupp, in his book From White Australia to Woomera, says the Pacific solution cost $500 million in less than a year. In another report commissioned by Oxfam and Adjust Australia, it's estimated that the cost was $1 billion between 2001 and 2007. The department was more forthcoming at that Senate committee inquiry about the numbers of people that eventually came to Australia anyway, despite the Pacific solution. The result was that around 60% of those determined to be refugees were resettled in Australia at the end of the day. So a lot of money spent to have 60% of the people coming to Australia anyway. As for the interception operations, probably even more difficult to get a handle on, given that it's a matter of defence. That report commissioned by Oxfam and Adjust Australia says that based on its Senate Estimates Committee's figures, $99.7 million was spent on interception operations. So, some very expensive activities for not necessarily a whole lot of gain. I think it's doubtful that we can ever have zero arrivals, as the opposition seems to want, and the economic cost is certainly far too high. In any event, since when has success been measured? By shifting a problem to someone and somewhere else. And I want to look at 4 issues relating to the implementation of a successful policy on refugees. One is the importance of stopping people smuggling. That's certainly a factor that a lot of people have been focused on. Second, is Australia taking its fair share of refugees? Third, why do we have a refugee convention? Because that's a question that's often asked by people. And fourth, what are the benefits of continuing to accept refugees? So one common argument is that we need to stop people from getting on boats, and there's no doubt that people smuggling, which is now outlawed by a UN treaty, is a very dangerous activity, or can be very dangerous. People can die while travelling in the back of an overcrowded truck, or they can die when their leaky fishing boat sinks. The problem is that life is already so fraught for refugees and asylum seekers that they may be prepared to take the further risk of using a people smuggler. The reasons for irregularly entering a country and using a people smuggler are the combination of push factors, the persecution, the human rights violations to which people have been subjected, and the fact that the formal channels of migration are difficult, if not in fact impossible, to negotiate. If your reason for moving is a violation of human rights, then the formal channels for migration are in the humanitarian stream. And in order to be eligible for that, you will have to have crossed an international border. Remember, the definition of a refugee only applies once you're outside your country of origin in the first place, and avenues for orderly departure of potential refugees are extremely unusual and would be very fraught indeed. The total number of places in Australia's humanitarian program, including the on and offshore programs, so onshore for asylum seekers, offshore for resettlement, is 13,750. And it's been announced recently in the budget that that amount will not be increased. And we are in fact one of the leading countries of resettlement. The total number of resettlement places offered by the world is less than 1% of the world's refugee population. So the idea that there's a queue and that you can use formal channels of migration instead of a people smuggler to get to Australia is really very wrong-headed. You could, of course, if you are eligible, use other channels of migration. For example, come as a tourist or try and get a student visa, but obviously the ordinary immigration processes are not always appropriate, and they often don't respond to the emergency situation in which refugees find themselves. The majority of asylum seekers in Australia have arrived lawfully on a tourist visa, for example, and then applied for refugee status, but it's not open to everybody to do that. Australia, like many other countries, screens potential tourists from refugee-generating countries extremely carefully. Our border control really begins a long way from home at consulates and airports abroad. So the vast majority of asylum seekers only make it as far as the country next door. Frequently, refugees will have to enter those countries unlawfully in violation of their domestic immigration laws, and so countries of first asylum live with highly porous borders. They don't have the luxury of saying zero unauthorised arrivals at all. The country of first asylum will generally be a developing country or perhaps a newly industrialised country, and it may not be party to the Refugee Convention. Examples include Pakistan, where many Afghan refugees are sheltered, and India, which is close to Sri Lanka. The Australian humanitarian program, while comparatively generous, is but a drop in the ocean compared with the numbers of people who need resettlement. The world offers a mere 79,000 odd resettlement places. The total population, as we've just said, is 16 million. UNHCR estimates there are 203,000 urgent cases requiring resettlement. So refugees are often caught in an extremely tough place, and not surprisingly, they seek to move on. So there's a market for people smugglers because of the lack of legal opportunities to seek asylum in other countries. And the key to diminishing people smuggling then is to try and take away the market. One way of doing that would be to offer more resettlement places. So Australia could increase its humanitarian program from 13,750 perhaps to 20,000, for example. Another thing to do is to encourage countries of first asylum like Indonesia, for example, or like Pakistan, to become party to the Refugee Convention and to offer adequate protection so that people don't need to move on. There'll only be an Indonesian solution if there's an Australian solution. But unfortunately, the focus of our regional cooperation measures like the Bali process appears to be on the export of border control mechanisms, to use Stephen Castle's words, such as funding detention centres. So we're looking at the problem from the wrong angle, and in so doing we punish asylum seekers and our behaviour actually begins to resemble that of the people smugglers. In a submission to the Senate Legal and Constitutional Committee inquiry into the Anti-People Smuggling and Other Measures Bill of 2010, Sue Hoffman shares some of her field research on the interceptions that took place in 2001. She writes, 4 boats were turned back in 2001, civs, suspected illegal entry vessels, 5, 7, 11 and 12. I have first-hand accounts from passengers on 2 of them. Based on these accounts, their boats were in no condition to do the return journey. Although some repairs were done at the time the boats were intercepted by the Australian Navy, the boats broke down after the Navy left and before the boats reached the Indonesian shoreline. Local fishermen rescued passengers on both boats. By this time, they were physically and emotionally exhausted, having had little sleep or food in the 10 or more days since they started their journey. One man I spoke with still has nightmares about it. 3 men disappeared and are believed to have drowned trying to reach land after Civ 7 ran aground about 300 metres from the Indonesian coastline. She concludes, much is made by both sides of politics that people smugglers put vulnerable people's lives at risk by sending them to Australia in wooden fishing boats. If politicians argue for returning these boats to Indonesia, then they should be aware they would be putting people's lives at risk in exactly the same way as the people smugglers are accused of doing. In addition to asylum seekers who bear the brunt of our deterrent policies, we need to think about the ramifications for the rest of the world. Now, Australia contributes to the resolution of refugee problems in a number of positive ways, through acceptance of asylum seekers, participation in resettlement and donations to UNHCR, among others. And yes, UNHCR, the chief body for dealing with refugees, is funded by donations by member states from the UN and indeed by individuals. So if we look at what Australia donates, we're here at number 13 on the list of donors, and we donate about $28 million annually to UNHCR. When GDP is taken into account, UNHCR puts us as 16th on the list, so that's a subtle message that perhaps we could be doing a little bit better. When we look at our GDP, which is about $1 trillion US, we're giving around 0.0028% of our GDP to UNHCR. Our total overseas development assistance program is $3,818.8 million. And when compared with gross national income, slightly different figure from GDP, please don't ask me to explain, that amounts to only 0.34%. The target recommended by the Development Assistance Committee of the OECD is 0.7% of our gross national income, and Australia is well behind other developed countries when it comes to official development assistance or aid. Okay, so that's us in terms of donations. What about our contribution in actually hosting refugees and asylum seekers? Speaking of figures, Julian Burnside has estimated that at current rates of boat arrivals it would take 30 years to fill the MCG. So fairly small number of arrivals. Some more official statistics prepared by UNHCR dealing with both authorised and unauthorised asylum seekers, so people coming on a visa as well as boat people, have been prepared. And so they have prepared charts that look at our receipt of asylum seekers per capita, and we see there that Australia has a pretty small number per 1,000 Australians, 0.3 of an asylum seeker for every 1,000 Australians in 2009, and that's well below the figures for other comparable countries. When we think about the situation relative to our GDP, and I should say that the UNHCR actually looks at GDP in terms of purchasing power parity, so what does the dollar actually buy? When we look at that, the number is even smaller. We're down to 0.2 per every US dollar of GDP per capita. So a pretty small problem in terms of receipt of asylum seekers, well below other comparable Western developed countries. Now those figures are for asylum seekers. They don't include the offshore humanitarian programs or resettlement. So how is Australia doing on that? Well, as I've said, the world offers very few resettlement places. So UNHCR tells us that in 2008, a total of 88,800 refugees were admitted by 16 resettlement countries. So not a lot of countries really participating in resettlement. They include the United States at 60,200. Australia is second on the list at 11,000. Canada, Sweden and Finland. So comparatively, I suppose you could say we're reasonably generous on resettlement, but it's still obviously a drop in the ocean. The question is whether less than 1% of the world's refugee population is good enough in terms of resettlement places, and whether our relatively good participation in resettlement lets us off the hook when it comes to onshore applicants for refugee status and unauthorised arrivals, or boat people in particular. In another helpful table, UNHCR gives a sense of the total refugee and asylum seeker hosting in terms of a country's capacity, so relative to GDP again. When you look at that list, the top 25 contributors are all in the developing world, and they include 15 of the least developed countries, and Pakistan is number 1 on the list. The first developed country is Germany, coming in at 26, and we go down the list, the UK 43, the US 46, Canada 52, and Australia at 79th place. We'd certainly be very unhappy with that number if we were participating in the Olympics. And that is 79 out of 171 countries and territories. So I think those figures tell us that if Australia is to take a fair share, it's not permissible for us to substitute offshore resettlement for onshore claims, even if that was possible, and I don't think it is. The figures of boat arrivals that we looked at told us that even with very tough measures, boats were still arriving in Australia. Although the eminent refugee scholar Jim Hathaway has argued for common but differentiated responsibilities towards refugees, he doesn't support Australia's stance that it can have zero unauthorised or onshore arrivals. If Australia is committed to the principle of non-refoulement, it has to lead by example, and that means accepting onshore applicants, including unauthorised arrivals or boat people. Well, one response to the challenges raised by refugee protection is to question, well, should we have a refugee convention at all? Why do we do this? Arguments that the convention are outdated come from at least two directions. One line of argument is the definition is too narrow, and it certainly is a very tight definition, and that to exclude people who are trying to escape poverty, even if there's no persecutory element, is arbitrary. Now, I think there's some truth in the idea that the convention is backward-looking, it doesn't capture all cases of need, and it certainly doesn't tell us why it's not okay to be complicit in persecution by sending someone home, but it's okay to be complicit in other abuses such as general poverty. Why is it okay to send someone back to that? But I don't think that's a very convincing argument for ripping up the convention. Governments have been prepared to extend the norm of non-refoulement a little bit, so to violations like torture or enforced disappearance. I think it's extremely unlikely that they're going to extend the norm so far that it encompasses all cases of poverty. That would risk swallowing up sovereign control over immigration totally. Now, of course, some people argue for open borders. Another response might be, you can have sovereign control over immigration, but why not be more honest about acknowledging labour demand? If we think about the United States, it's a very good example. There's heated debate about illegal immigration, even though we know the economy actually needs all of the unauthorised workers who are denigrated and punished and labelled as illegals. There's even been a movie made about it, A Day Without Mexicans, and what would happen to the United States if there were no unauthorised workers there. On the flip side, the fact that the Convention is limited to very specific situations could be viewed as a plus. If its relatively constrained nature means that governments continue to adhere it, then that gives human rights lawyers some real bite. Frequently, as human rights lawyers, we complain that we can't enforce it, nothing ever happens. Well, a Refugee Convention does give some real protection to people. And I would argue it gives us an immediate way of doing something positive that is far less harmful than, for example, humanitarian intervention. Recall when justifying the NATO action in Kosovo, the former British Prime Minister Tony Blair, we said we must do something or do nothing. But military intervention, of course, carries all sorts of risks, death amongst them. So in contrast with this muscular humanitarianism, as my colleague Anne Orford has called it, the Refugee Convention respects the Hippocratic Oath, first do no harm, and it offers us an easy and simple way of doing something positive. That's not an excuse for failing to deal with root causes at all, but in order to properly deal with root causes, it isn't sufficient to just intervene at a crisis moment and then go away the minute there's been an election or two. As Stephen Castles has argued, in order to deal with root causes of migration, whether from human rights violations or more generalised poverty, there has to be a commitment to dealing with the fundamental inequalities between North and South. And he argues that in the long term, generation of greater parity in living standards would decrease pressures for South-North migration, even though in the short term development might actually lead to increased migration. So as a start, we might start by meeting the OECD recommendation that we spend 0.7 of our gross national income on official development assistance. A different criticism of the Refugee Convention focuses on the potential impact of countries of asylum, and these criticisms are articulated on a number of grounds. One is essentially the argument that if we allow spontaneous movement to Australia, we'll open up the floodgates. That fails to deal with the very limited nature of the refugee definition, the thing that some others criticise, and the fact that failed asylum seekers are often returned back to the place from which they came. It also fails to acknowledge that not everyone in dire poverty is moving, and in fact those people are far less likely to move than the emerging middle class in the developing world. Other ways in which this argument is articulated are the needs of Australian citizens and concerns about the environment. And these, of course, are perfectly legitimate concerns to raise. But I don't think it's a question of choosing between providing for our own citizens and providing for these others. Even if the MCG does fill up in the next 30 years, that's hardly going to prevent Australia from dealing with Indigenous rights, homelessness, health, education, or the environment. I'd argue that in Australia, the politics of border control has proved a distraction from those very important issues. Consider the fact that Jim Jupp thinks $500 million went down the drain on the Pacific solution in less than a year, and that's the same figure as the one-off amount allocated in 2008 under the Better Universities Renewal Fund in order to compensate for the Howard government's cuts to universities. Well, hopefully I've done enough to put to rest arguments against accepting refugees in general and boat people or unauthorised asylum seekers in particular, and it's now time to focus on the positives, the benefits of being a good Samaritan, if you will. The Refugee Council of Australia recently prepared a literature review on the economic, civil and social contributions of refugees and humanitarian entrants. And this report demonstrates that although there are some short-term costs to resettlement, overcoming barriers to people working and setting up special employment centres and so on, there are long-term benefits. Given these significant barriers that refugees face, I think the contributions are absolutely remarkable. If we take the Afghan community in Young, who feature in that wonderful documentary Molly and Mubarak, they apparently contributed 2.4 to 2.7 million over 18 months to the regional economy. Broader studies show that economic contribution of humanitarian entrants is positive after 10 years and increases from then on. The Refugee Council's report also shows that refugees have an entrepreneurial bent, with one study finding that 21% of refugees receive their main income from running their own business, which of course can employ other people, and also that in 2000, the Business Review Weekly's annual Rich list, 5 of Australia's 8 billionaires had actually come from refugee families. Other benefits include the remittances sent home that help contribute to the survival and possibly development of communities, possible development of trade links between countries, and greater cultural diversity. The Council found that there hadn't been enough research that differentiated between the contribution of migrants on the one hand and humanitarian entrants on the others. And it recommended that existing government surveys of migrant experiences gather and disaggregate that data. And that's important because if in fact the contribution of refugees is as positive as most advocates believe, then telling that story could do a lot to eliminate the negative stereotyping of refugees. It's time to change the national conversation about refugees and boat people. The way in which we talk about boat people is deeply detrimental to our national fabric. By denigrating boat people, we risk their social exclusion. We know that mandatory detention causes mental illness and slows the capacity of refugees to integrate. We may create ripple effects for Australians of migrant background. The fear and stereotyping that goes on around border control could have significant negative impacts on visible minority refugees. And those impacts would not be limited to unauthorised arrivals, and indeed they could impact on migrants who've been in Australia for many years. I don't think it's outrageous to say that hysteria around border control could easily lead to race riots on the beach. We also waste time discussing the unrealistic possibility of preventing a phenomenon over which we cannot exercise unilateral control, instead of directing our efforts outward in a compassionate and cooperative fashion, and we're distracted from other issues that we should be focused on, such as climate change, health, education, Indigenous rights, and so on. Now, I think that a National Bill of Rights would be a very important step forward in changing the national conversation about refugees, but if we can't have that, and apparently we're not going to have it in the short term, then I think we need a concerted education campaign about refugee issues, and I think we should start in school. Every school child in Australia should know the real refugee story. They should know and understand what persecution people have suffered. They should know that refugees helped to build the Snowy Mountains hydroelectric scheme. They should know about children just like them who have suffered in detention. And that's a picture painted or a picture drawn by a child asylum seeker that's available on the Chill Out website. They should know that there's nothing to be frightened of and that we gain everything by welcoming refugees. We need to work on turning around public opinion so that come election time, politicians stand to gain nothing from idle claims that they will turn the boats around. Thank you.
Now, Penny has said she is willing to answer a couple of questions, which we'll have time for before we'll hopefully all adjourn to have some refreshment upstairs. So are there any questions? And you'll have to put your hands up because I suspect Penny's as blind as I am from the light that's going from there. So
There's a question just
yes,
there.
yes.
I'm just wondering, in light of Bigotry trying to stop the demand for people smugglers, would it be legally possible, if it doesn't legal to do so, for Australia to process their funds in Indonesia, considering we fund detention centres in Indonesia,
Yep.
and then it needs to be that they're a country of transit and not one of reception?
Yeah,
Is there
absolutely.
something to assume
Well,
the department processing funds in
yeah, I mean, you'd have to have the cooperation of Indonesia, but that might be the sort of cooperation that they would welcome. They're certainly not willing to have us just sending people back there. They do participate in the sense of detaining people often, why not explore those sorts of avenues? And that would certainly cut out the market for people smuggling. And certainly reputable commentators have been suggesting that idea, it just hasn't been picked up yet.
What are your thoughts on the moral and perhaps financial obligations on Australia if, for example, as a result of the increased sanctions on Iran, the authorities there decide to drive the 1.5 to 2 million Afghanis back across the border?
So you're asking me, do we have moral responsibilities in cases where we've intervened in particular countries or we're imposing sanctions? Yeah, I mean, I think we do. If we're going to intervene in those sorts of situations, then we must accept some responsibility if there are then refugee flows. It is a moral argument, though, not necessarily a legal one. Yes, Helen.
I wonder if you'd like to comment on the Australian Human Rights Commission report on children in detention and the impact that had on practice.
Well, I wish it was acted on, really, is essentially what I'd say about that. I mean, there were, so Herriot prepared, I think it's about 10 years ago, 1997, a report on children in immigration detention and documented what happened to little people like the person that did this drawing. There was some sort of public groundswell around that report, and I think people did acknowledge the impact, and it did affect a kind of shift in public thinking on the issue. And in fact, the Howard government did start to act on that. So Amanda Vanstone, as Minister for Immigration, and I don't think she's ever really received enough credit for this, did start to soften the policy. So families and children would be placed into a form of community detention. The problem was, of course, with such low arrivals of boat people, that policy wasn't really going to affect as many people. Currently, the new government, the Rudd government, really the old government now, aren't they? But the Labor government, they announced just before I left for the States, actually, a new set of detention values, and the idea was that we would only detain based on risk, and there's still a bill before Parliament that's supposed to encapsulate that idea and put it into law. The reality is, however, we know that all boat people are being detained mandatorily on Christmas Island. There is some dispute between the government and the Australian Human Rights Commission about whether children are still being held in detention. The government says the construction site on Christmas Island is not a detention centre. The Australian Human Rights Commission, and I support them in this, says yes, it is a detention centre. So in practice we are in fact still detaining children. And of course, you know, perhaps if we focus on that a bit more, that might swing public opinion around. So thanks very much to a question from the ACT's Human Rights Commissioner, Helen Watchers.
Time for really one more question. So,
maybe a silly question, but you're looking at statistics over a period. I wondered if you had any view on social trends and attitudes that give a comparison going back to a boat, say in 1945, the Dem era, and the way people on that were received in Australia.
It's a wonderful question. I'm not sure I can answer it. I haven't really thought about it in depth. I think we've had a kind of cycle of it's a bit like being in Groundhog Day, actually, as a refugee lawyer. There's a sort of cycling, a realisation that actually refugees do benefit. And you've mentioned the Dunera, you know, the boat on which all of these talented refugees arrived. And I think Australians did begin to think, yes, this is a good thing for Australia. I can remember as a very little girl meeting one of the Dunera boys, Dr. Paul Shatsky. And so I think that did have a change, but we seem to quickly slip back. Perhaps as a result of politicians just jumping on it. It makes us feel safe to say, look, we're a government that's strong on border control. You know, we'll protect you in this way, and it distracts our attention and it makes us forget I mean, it is extraordinary. As Helen's raised this example, we all got very concerned about children in immigration detention 10 years ago, and already the public is beginning to forget that, and also forgetting the costs of the Pacific solution. We've forgotten that it was a very expensive exercise.
Well, I'd like to thank Penny again very much for this lecture, and ask you all to give a round of applause and then join us upstairs.